Welcome everyone to our third basic course on international patent filing. In this course, we will be understanding about international patent filing, ways to file an international patent, their forms and fees. So let's start with the first question. What is international patent? So in reality, there is no term called international patent. What I mean by this is there is no single authority who can give you a grant for a patent in all the foreign countries. So there is no term called global grant. This term international patent is used to file a patent through two different ways. So for each jurisdiction there is a separate patent office who authorizes or decides a grant about your patent. Now let's talk about the criteria and deadlines to file an international patent. So for an Indian applicant, there is a criteria that he or she should take permission from the Indian Patent Office in case he decides that he only wants to file a patent in foreign country and not to file first application in India. Then he needs or she needs to take a permission from the Patent Office to file a international patent. In other case, if he or she decides to file a patent in India and then goes for an international application, then they get a 12 months time to file a patent internationally. Now there are two routes to file patent internationally. We'll talk about them. Before knowing the routes of filing patent internationally, we should know why to file a patent internationally. Why someone should decide that a patent should be filed internationally. First is it enhances the value of your invention. So if you are filing in more than one country, apart from India, if you are filing in some other country, residents of those countries are also restricted to use your invention without your permission. And if they use, they have to pay the royalty to you. So obviously it increases the value of your invention. Next is it increases the scope of commercialization, because since you are filing in more than one country, the scope or the commercialization market has been increased for you. Increases chances of getting funding from investors. So investors generally prefer for internationally filed patents because that gives them more scope to commercialize. Then apart from these advantages, there are some drawbacks also to file an international patent. So those drawbacks are complicated procedure and non-uniform IP laws across various jurisdictions. So each country, each jurisdiction has a different IP law and the procedures are very complicated. So this adds a confusion to the inventors or applicant's mind that whether to go ahead with this country or not. Even if he decides to go ahead with that country, at every stage he has to face a different procedure for different country. So this is the only drawback for filing a patent internationally. Now what are the routes? So there are two types of routes to file a patent internationally. First is convention application route and second PCT application route. We will talk about both of these routes in detail. Let's start with convention application route. So countries which are members of Paris Convention are called convention countries. The application filed in these convention countries is called convention application. So when you file a patent application in any of these convention countries, your application will be considered as a convention application. Now there is a timeline to file a convention application. This timeline is 12 months from your priority date. So suppose today, if you are filing in India, your first application, you get a priority date for today. And then from today, you get 12 months of time to file all the international application you wish to file. Suppose you decide to file in 4 countries, Japan, USA, Canada, and then in some countries of Europe. Then in all those 4 countries you have to file a patent application within 12 months. So this is what convention application timelines, and what you mean by convention application. Now let's talk about the second route, that is Patent Cooperation Treaty route. So that is called PCT route. So PCT is an international patent law treaty that provides a unified platform to file a patent application in any of the contracting states. So there are some states or contracting states who have signed a contract called International Patent Law Treaty, and these, when you file a patent in any of these contracting states, your application is considered as PCT application. PCT is an agreement for international cooperation in the field of patent. So to cooperate in the field of patents, this treaty has been signed, and it's a special agreement under Paris Convention. Note that it is a single window for multiple countries. Here you need to understand that it is a single window system, that is a unified platform. It is not saying that it will give you the grant for multiple countries, but it is only a platform to file a patent in multiple countries. But the grant of your patent will be decided by the separate or individual patent office of that jurisdiction. It is not decided by the PCT. So you have to note that PCT is a evaluation system of patent at international level. It only evaluates your patent, and it does not provide a grant to your international patent. It only evaluates. Grant is provided by the individual patent office of that particular jurisdiction. This is a pictorial view of filing international patent. So first, suppose you have filed in India, then within 12 months you have a time to decide whether you want to go for a convention route or you wish to go for a PCT route. So suppose you decide to go for a PCT route, then you have to file a PCT application, and then we'll talk about the later stages of PCT in detail. And then there is another route, that is convention route, in which you have to directly file in various countries in which you wish to file. So suppose 3 countries you have decided, so in all these 3 countries you need to file patent within 12 months time. This is convention route. However, in PCT route only 12 months time is given for PCT application, not for the countries. Here you just have to file a PCT application. So what is the PCT application procedure and what are the stages in PCT application? This is the more detailed view of PCT and convention, that is difference in timelines. So in convention, I already told you that you first file in India. Suppose in India, this is common for all the countries. So suppose you file first in India, you get the priority date, and then within 12 months you decide to go in any of the countries. Next is PCT route. So here you first file in India, and then you get a 12 months time to decide or to go for the PCT application. The due date for PCT application is 12 months. Once you file a PCT application, that is a unified platform for all the countries. Here you get 30 months of time from your first filing or priority date to decide the countries of your choice. So basically this gives you more time to decide the countries. 30 months time is very important timeline in PCT, and that is what makes PCT route more convenient and more important. So that is why people choose PCT route more, because it gives you a good timeline to decide the countries, and then also within this 30 months the applicant gets the time to raise the funds, because to file a patent in various countries fund will be needed, fees will be needed. So for that he can get some funding from some agencies or some research fundings he can get, and also he can decide whether that particular country is desirable or not. However, in convention route this timeline is very small for an applicant to decide in which country he wishes to go ahead. So these are some PCT contracting state. I told you that PCT is an agreement for international patents, and there are some contracting states who have signed the agreement, and there are some around 148. There may be more, some few are added, so this is not the updated data, but roughly around 148 PCT contracting states are there. These are mapped in this blue color on this world map, and these include some this excludes some countries, which is Taiwan, Pakistan, Argentina, etc. And India became member of this PCT on 7 December 1998. So from 1998 onwards, we are eligible to file a PCT application internationally. So this is the first stage till the transmittal publication happens, and from here directly you can go to PCT, because after 30 months this will come as an by default. But in case any of these three options are taken, then that becomes a chapter 2. So this is chapter 1, this is by default happening, and after chapter 1 you can go directly to the PCT national phase, that is after 30 months only. But in this period, if you decide to go for any of this, then it becomes chapter 2. So see what happens in chapter 2. So this is chapter 1, this is the end of chapter 1, and you go to the national phase entry. Now chapter 2, so in chapter 2 there is again an option of amendment and demand for international examination. So suppose you demanded for second international search, and then based on your search report you amend your application, and then you again file a examination request. Now international preliminary report on patentability will be also judged on these three criteria only. So because this is an option, you can again, you are going for the secondary or supplementary examination, but this will be based this will be judged based on the same criteria, that is patentability criteria. And this ends the chapter 2, and with the chapter 2 you can go to the national phase entry. So this whole chapter 2 is a optional chapter 2, wherein applicant wishes, if he wishes to go ahead with this chapter, then he can go, otherwise after 30 months by default he has to go to the national phase entry. Now what happens in the national phase? In the national phase, an applicant chooses or decides his countries. So if an Indian applicant applies for PCT, he has options of all the 148 or more PCT contracting states, and then he decides suppose 2 countries. So when he decides that he wants to go for those 2 countries, later on he has to proceed or he has to follow all the procedures of those particular 2 countries. So suppose USA and Japan, I have decided to go ahead. Now whatever the procedure US jurisdiction or US patent office follows for filing a patent application, the format of patent application, format of writing claims, drawings, then forms, related forms, fees, like we have an Indian patent application system, same way a US patent application system will be there. So an applicant has to do all those formalities based on particular jurisdiction. Same way he has to go for Japan, so Japan will have some language barriers also, so he has to convert his application in Japanese language, and then he has to go ahead. So whatever country or jurisdiction you choose, you have to follow the rules of that particular jurisdiction. PCT won't be doing anything, or PCT won't be helping you to do anything. There are some routes to convert your application in that particular languages and all those things. PCT will be a medium or a platform who will be just transferring your documents from your PCT platform to the country in which you desire to go ahead. So from PCT platform, your documents, whatever documents you have filed, will be transferred to the US jurisdiction and to the Japan jurisdiction, and then whatever further things will happen will be decided by the individual jurisdiction, and grant of that particular patent will be only decided by that particular jurisdiction only. If US is, if you are filing for US will decide, maybe US can take references from PCT search reports, but this is not compulsory. US can also decide not to give the grant even if the ISR, that is International Search Report, has given you has given a good report and has said that your application is very good, like it has inventive step, novelty and patentability criteria. But if US does a search, because when you go to US will also do the search again, like in India we do the examination. So same way US will also examine your application, and if US people or jurisdiction find some application which are relevant and which are objectionable to your patent application, they may decide not to give the grant. So the grant of a patent is based on or is decided by the individual jurisdiction only. So next is filing strategies. Now I told you that you need to decide your ISA, that is International Search Authority. Same way you need to decide your receiving office also. So if you are an Indian applicant, basically by default you decide India as your receiving office only. So that is not compulsory, but usually people decide that. But you also have an option to choose International Bureau as your receiving office. So when you choose International Bureau as your receiving office, your patent application or PCT application number will be like this, which includes IB. And in case you decide your nation as your receiving office, then suppose you have decided India, then you get the application number like this. So suppose a US resident decides US as receiving office, then it will come as US here. Then there are some regional offices also, that is African Patent Office and EPC and Eurasian Patent Conventions. In this you can also take Regional Patent Office as your receiving office. Now filing strategies. So we have talked about that what are the ways to file international application, where to file, whom to choose. Now what to file in an international patent application. So this is similar to our Indian patent application only. You have to file all these things like specification with claims, you need to submit abstract, you need to submit a drawing, all the inventor details, applicant details, priority details. Priority details means if you have filed already a invention patent in India, then all the details of that particular application should be given here, and sequence listing in case you have filed a biological patent application. Then language, so whatever languages are acceptable to your receiving office. So suppose a Japanese is filing a PCT application and he chooses Japan as a receiving office, then he can file a patent application in Japanese language also, because his receiving office is Japan and Japan accepts a Japanese language patent application. But if in India, if you are filing, then India accepts English. So you have to file a patent application in English. Then how to file? So what is the e-module system of this patent application? So there is an offline as well as online mode for filing a PCT application. Now electronic filing, so there is a site called ePCT and you can use the software PCT Safe. When you go to ePCT, there is a PCT Safe called software where you click, and then this software offers PCT users the means to prepare their international application. So there are a lot of user manuals in PCT wherein you can prepare your international application. So because you already have your draft filed in India, you can use that same draft and you can just use this software to prepare the PCT format of your application. And digital signature is required to file a patent for second like authorization. Then it can be downloaded from the PCT website, and specification text and drawings should be in any of these formats. Now here few people have doubt that whether you need a foreign attorney to file a PCT application or not. This is a myth generally, but here I would like to clear that myth, that a person who has filed your Indian application, they are eligible to file your PCT application as well. You don't need a foreign attorney to file a PCT application, because whomsoever has filed your Indian application, they will know the drafting skills of international patent application as well, and they have a right to use the PCT Safe software, and they can create their digital signature over here. So you don't need a foreign attorney to file a PCT application. However, when you go ahead at the national phase entry, when you decide to go ahead with US and Japan and any of the country, that time you will be needing a foreign attorney. But for the PCT stage, you don't need anyone to file a patent application. Basically, you don't need anyone from the foreign. Applications are entitled for fee reduction on electronics fees. So, like in India, PCT also gives some reductions when you file the patent electronically, that is e-filing. Now, these are some forms which are like not you have to manually fill this form, but these are the forms which are received or which you can see when you file a patent application through PCT. So, this is a notification of receipt of record copy. So, when you suppose you are an Indian applicant and you file a PCT application and you take India as your receiving office. So, once you take India as your receiving office, PCT will take your documents, and if you have already filed in India, so your all the documents are already there in India. So, this is a record copy. When the PCT and receiving office communicate with each other for all the recorded copies, this notification comes to you or your attorney that they have received all the recorded copies. Then notification concerning submission, obtain or transmittal of priority document. So, this is the same which I told you earlier. So, that your receiving office will transmit your priority documents to the PCT module or platform. Then next is undersigned request for international preliminary examination. So, when a person, that is an optional applicant decides to go ahead for international preliminary examination, then he has to fill this form, that is chapter 2, right. So, next is fee structure. So, when you file a PCT application, there will be some fees involved, and first is international filing fees. So, international filing fees is only filing a PCT application, that is the international phase, and not for the national phase countries. So, when you go ahead for national phase countries, you have to pay the fees of that particular jurisdiction again. This is only for the national phase fees, international phase. So, PCT fees is international fees. This is like this comes in dollars, and this is around 9 to 10,000, which keeps changing as per the market rate. Then search fee, that is it depends on the ISA chosen. So, International Search Authority, if you choose India as International Search Authority, the fees is around 2,500. I am not sure about the latest updates, but this is about 2020, it is 2,500, and this search fees can change because if you decide USA as your searching authority, the fees will be different. Then transmittal fees, this fees is taken by the receiving office to transmit your priority documents to the PCT. So, basically I already told you in earlier slides that whatever documents you are filing in your receiving office at the time of first filing or priority filing, those documents are transmitted to the PCT, that is from your receiving office to the PCT, and receiving office takes some charge to transmit this documents. But if you are filing an e-application, that is online electronic filing, then receiving office is not receiving fees is not applicable, that is transmittal fees is not applicable, because that is done online. So, basically they are not doing any post or courier to transmit your application or documents to the PCT. So, there is no fees, but in case you file offline application, in that case there will be a transmittal fees involved. With this we will conclude for the advantages of PCT. So, we have learned about two routes, PCT and convention route, and in between also I told you why PCT is more convenient, but if you decide to go ahead with one country, then convention route is more convenient, but for two or more countries PCT is more convenient. Then what are the advantages? PCT provides an additional time. This is the most important part of PCT because it gives 30 to 31 months. So, few countries have a timeline of 30 months and few countries have a timeline of 31 months. India follows 31 months timeline from the priority date to file a patent application in various countries. So, this timeline gives an advantage in is an advantageous factor in PCT. Then additional time helps to gather a better understanding of the market potential, as I told you, because this timeline will help you to explore the market potential of that particular jurisdiction of for your product, and then helps in developing a more effective worldwide strategy as well as determining the strength of the innovation. Because since you get an additional time, you get a time to decide various factors. Then PCT provides for not only a faster option but comparatively more economical, because it only costs you around 15 to 20,000 hardly, or 25,000 to file a PCT application. In this fees you can decide whether to go ahead or not. Of course there will be different fees for the jurisdiction basis also, but PCT will only cost you this much for 30 months, and if you decide not to go ahead, then you are saving the money for like filing for an application. But in convention you have to like only get 12 months and you just pay the fees whatever is required by the individual jurisdiction, and this is a faster option, comparatively more economical. So with this I conclude our session. I know this was not very much detailed section because PCT is a very vast subject, and this is our just a basic course, and I hope I have covered all the sections which should be known by a person who is willing to go ahead with the international filing. In case you have any doubts, or if you are wishing to take our services for PCT filing, you can contact us on this details, and also you follow us on all the social medias, especially on Instagram and LinkedIn, because we will be notifying about other courses which are professional courses very soon, and also we will be taking revision of these basic courses on Instagram. Thank you very much.